agents need to be aware that directors aren't getting that information, and the first the director might hear about it is once they receive a DPN. Hi, I'm Michael Buscema and I'm Practice Lead of Tax Disputes here at Aptum. Today I'm answering questions we commonly receive from both directors and agents about director penalty notices. Why is the ATO issuing so many DPNs? Well, there's two main reasons. The first reason is the actual tax types that are mostly owed out there in the community. And the second reason is to actually change the payment behaviours of taxpayers. Regarding the first, of the fairly significant collectible debt problem the ATO has at the moment, the majority of that debt is owed by small business, and a lot of that debt, in fact most of it, is pay-as-you-go withholding or GST debt, which are debts that the ATO can issue director penalty notices in respect of. The third, of course, being superannuation guarantee charge, which has always been a focus for the ATO. So sending DPNs is a good way, one of the best ways for the ATO to address those tax types for which there's a lot of tax debt. The second point is that the whole intent behind the director penalty regime is to encourage companies to confront their debts earlier. Now, we saw through COVID where companies were allowed to trade on while building up tax debt when the ATO took a back seat, that they came out of COVID and found themselves with an unmanageable amount of debt. So part of the reason is the ATO is sending director penalty notices to catch up and claw back debt. But a big part is actually to send these perhaps a little bit earlier so that directors can ensure that their companies confront these debts as they start to escalate and they don't build up to a point where they necessarily collapse and they owe the tax office and other creditors a lot of debt. Is the ATO going to keep issuing this many DPNs? Yes, but probably not in the way you expect. Typically, the ATO has sent DPNs after a period of trying to contact the company to get payment, and they've used DPNs as a form of firmer action. However, what we saw over COVID was that the entities who didn't pay for a period of time build up a debt, but when the ATO comes to collect the debt, the money's no longer there, which is of a disadvantage both to the ATO and often other creditors. So what you will probably find is the ATO sending DPNs much earlier, when the company still has the money to be able to meet these debts, but also directors are in a position to consider in real time whether or not they should try to trade their way through, whether it's appropriate to take action to put the company into, say, an insolvency process. What are the warning signs before a director receives a DPN? So these are the things to watch out for. Number one, if the company gets sent a firmer action warning letter. The ATO will still be sending a firmer action warning letter to a company before a director gets sent a director penalty notice unless it's a more egregious type of matter. If you're a company director, you should be in conversations with your agent regarding the financial position of your company if it hasn't paid their tax debt to check whether or not the company has been sent a firmer action warning letter. Number two, do not wait for a director penalty awareness letter. These have been sent from time to time in the last couple of years, but there's no guarantee that these will continue to be sent in the future, and you should not expect one before receiving a DPN. Number three, there is no longer probably going to be as long a time between incurring a debt and receiving a director penalty. So if you know that your company is lodging a BAS or an SGC statement, and you know that that amount is not being paid, then you can expect potentially within a month to get a director penalty notice. So if you know there's going to be a debt upon lodgement, you need to take action either yourself or through the company's accountant to arrange for payment of that amount or some arrangement to avoid a DPN. What can directors do once they receive a DPN? There's often not a lot a director can do after they receive a DPN. Directors should do what they can to avoid receiving a DPN. So checking with the company accountant to make sure what the debt position of the company is, if that company's received a firmer action warning letter, or if you're making a BAS lodgement and you're not going to be paying on time for whatever reason, contact the ATO to come to an arrangement to avoid a DPN being issued. If the 21 days of the director penalty notice have expired, then you need to consider whether or not a defence applies. A defence can apply in situations where for a good reason, such as illness, or another good reason, you didn't actually take part in managing the company, or you took all reasonable steps to make sure the company complied with those obligations. If you feel like you are in that position and you have received a director penalty notice, you can contact Aptum for advice as to next steps. I was never a director of the company. Can the ATO recover a director penalty from me? The first thing to be aware of is that directors are required to be registered with ASIC. So if the ATO looks at the ASIC records and you are a director per ASIC, they will send you a director penalty notice. So the first step, if you don't think that you were a director, is to check whether or not you're registered with ASIC. If you were registered with ASIC, without you knowing, then there might be recourse to ASIC to update the records to reflect that. And if you are removed from the records, that may remove your director penalty liability. However, more commonly, we see people sign up to be directors of companies and think that they have more of a business role and they're not part of the financial management of the company. These sort of defences don't really apply. Directors are not treated any differently based on the roles within the company. If you are registered as a director, then you will be liable for a director penalty notice, and it's not sufficient for you to say, for example, I was just on the tools or I managed another part of the business. We are unfortunately seeing an increase in cases involving economic abuse, where people were potentially signed up to companies without their knowledge, or even forced to sign up to be a director of a company. These situations can be very difficult to work through, both for the taxpayer and sometimes the ATO as well. In those circumstances, if you were never involved in the company, that is something that firms like Aptum might be able to assist you in running a defence for. Alternatively, there are other lower cost support options out there, such as tax clinics that might be able to assist people in those circumstances. What are my options if other directors have assumed financial responsibility for the company? We also see a lot of cases where directors have reached arrangements with co-directors around who will be responsible to manage the company's financial affairs or to pay any shortfalls. If you find yourself in a position where the ATO has sent you a director penalty notice and there is an arrangement with your co-directors to cover the financial responsibilities of the company, then Aptum can assist you to both manage the proceedings as against the ATO, while we also consider options to pursue your course of action against these co-directors if they're not willing to cover the financial responsibility. What do agents need to watch out for with regard to DPNs? Agents are in a position where they are managing often the affairs of a company. Now, if that company is not paying their lodgements, particularly their BAS lodgements on time, or they're receiving correspondence from the ATO regarding outstanding debts, agents need to be aware that directors aren't getting that information, and the first the director might hear about it is once they receive a DPN. This is often a cause of dispute and may even lead to a potential negligence claim against the agent if the director was completely unaware of the financial position of the company. So agents need to be on top of the communications the ATO is sending the company to make sure that the director is aware of what financial position that puts them in personally to avoid any potential concerns down the line once the director receives a director penalty notice. If you have received a director penalty notice and the 21 days has expired, you can contact Aptum for advice as to your options.